and not for all series of banknotes. The power can be exercised for all series of banknotes merely because on 2 earlier occasions, the demonetization exercise was by plenary legislations. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. The second, subsection 2 of section 26 of the RBI Act does not provide for excessive delegation inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down on the said ground. In 3, the impugn notification dated 8 November 2016 does not suffer from any flaws in the decision-making process. 4, the impugn notification dated 8 November 2016 satisfies the test of proportionality and as such cannot be struck down on the said ground. 5, the period provided for exchange of notes while the impugn notification dated 8 November 2016 cannot be said to be unreasonable. And 6, the RBI does not possess independent power under subsection 2 of section 4 of the 2017 Act in isolation of the provisions of section 3 and 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1, section 4 of the 2017 Act. Having answered the reference, we direct the registry to place the matter before the Honorable the Chief Justice of India for placing it before the appropriate benches. Needless to state that all other contentions are kept open to be considered by the benches before which the matter would be placed. Before parting with the judgment, we place on record our deep appreciation for the valuable assistance rendered by Sri R. Venkatramani, the Learned Attorney General, Sri P. Chidambaram, Sri Shyam Diwan, and Sri Jaideep Gupta, Learned Legal Counsel, and all other counsels appearing for the parties.
All right, so that is the big breaking news that's coming in. In fact, Modi government's demonetization decision has been affirmed and upheld by the Supreme Court. In fact, these are the live visuals that we're getting for you on Mirror now from the Supreme Court as this judgment, a 5-judge constitution bench of the Supreme Court rejected the challenge by 58 petitioners to the Union government's 26th decision to demonetize rupees 500 and rupees 1,000 currency notes.
With regard to exercise of power by the central government, subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the Act for the sake of brevity, by issuance of the impugned notification dated 8 November 2016, hence my separate judgment. By way of preface, I state that the judgment proposed by His Lordship Gavai J does not recognize the essential fact that the Act does not envisage initiation of demonetization of banknotes by the central government. Subsection 2 of Section 26 of the Act contemplates demonetization of banknotes at the instance of the Central Board of the...
There has been a great restraint in manners of economic policy. Court cannot supplant the wisdom of executive and its wisdom. Decision-making process cannot be faulted merely because the proposal emanated from the central government. So, in a way, as of now, Supreme Court is not saying anything against the process that took place, and that is demonetization. And Supreme Court has said that the demonetization cannot be struck down on the grounds of proportionality. We know for a fact that our Supreme Court also sought the response from the central government and also from the RBI. And in one of the petitions, it was also being said that RBI was not being consulted by the central government before taking this decision, to which RBI has said that yes, there was momentarily problems for the people of the country, but this was being undertaken in larger respect, larger good of the people in the center. Government has also said that the demonetization, the decision was taken to ensure that the black money comes back into the system, that there was a massive tax evasion, and hence to strike down at that, demonetization took place way back in 2016. Now, while we speak, the hearing is still going on, but the Supreme Court have clearly stated, and as of now, what we can break is that the Justice Gavai has said that notification dated in November 8, 2016, that is demonetization, is valid and satisfy the test of proportionality. So the constitutional validity of demonetization, which was being challenged in these particular petitions that were filed in front of Supreme Court, the Supreme Court has said that notification dated 8 November 2016, that is of demonetization, is valid and satisfy the test of proportionality. But we also know for a fact that it's a constitutional bench, and hence two judges have written down their order. It was the order from Justice Gavai. Now,
All right, so that was our correspondent Mohit getting us the latest on that front, where he has said that Justice Gavai has upheld the decision of the demonetization decision, gone on to call it valid and satisfied. In fact, 58 petitioners had challenged it. This is in connection with the demonetization which came into effect in the country on 8th of November 2016. So that is the big breaking news that's coming, where the top court has upheld this particular decision. And also just talking about the 5-judge constitution bench of Supreme Court rejected the challenge by 58 petitioners to the Union government's 2016 decision to demonetize rupees 500 and 1,000 currency notes, saying the decision being executive's economic policy cannot be reversed and the decision-making process is not flawed. So that is the big development that is also coming in at the moment. On the other hand, just to look at the arguments, the counter-arguments that was made in the court earlier, in fact, for the petitioners, it included senior advocates P. Chidambaram and Shyam Devan, where Chidambaram had pointed out that the scrapping of rupees 500 and rupees 1,000 currency notes was deeply flawed. Whereas now the big development coming in, where the top court has gone on to say, like my colleague Mohit was also pointing out, that Justice Gavai has of course given the verdict, going on to say that it is complete, valid and satisfied at the moment. Now, in fact, revisiting the Supreme Court's attempt
Stated at this juncture that the said aspect of the matter is not one of form, but of substance. Therefore, examining this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization, and is therefore well within the limits of the Lakshman Rekha that this court has carefully drawn for itself. When I have analyzed section 26 of the Act interpretation, there I have made again a table with a view to lend perspective to the issue, with the discussion to follow. A bird's eye view of my analysis and conclusion has been expressed in a tabular form. The parameters for distinction. Then second, when the proposal for demonetization originates by way of a recommendation by the Central Board of the Bank. And the third is when the proposal for demonetization originates from the central government, as in the instant case. In that, I would say role of the central government, and the second parameter is role of the bank. The third parameter is extent of demonetization that may be proposed and carried out. Fourth, considerations for proposed measures of demonetization, illustrative. 5, process or route to be followed to carry out demonetization. And 6, applicability of subsection 2 of section 26 of the Reserve Bank of India Act. There I have stated that when the demonetization originates by way of a recommendation by the Central Board of the Bank, it is section 26(2) which applies. But when the proposal for demonetization originates from the central government, as in the instant case, it is not under section 26(2) of the Act. It is to be by way of a legislation. And if legislation is not the way, in the sense there is need for secrecy, then it is ordinance. For initiating the process of demonetization, the next question would be whether the central government can, on initiating the process of demonetization, proceed to issue a gazette notification to demonetize any or all series of any or all denomination of banknotes on the strength of subsection 2 of section 26 of the Act. Consideration of this issue would also answer the contention of learned senior counsel for the petitioners regarding subsection 2 of section 26 of the Act being unguided and arbitrary in nature and hence unconstitutional. To this end, the following aspects have to be examined. A, whether demonetization can be initiated and carried out by the central government by issuing a notification in the Gazette of India as per subsection 2 of section 26 of the Act. B, extent of the central government's power to carry out demonetization, that is, whether all series of all denominations may be demonetized. As held herein before, the proposal for demonetization can emanate either from the central government or from the central board of the bank. It is, however, necessary to contrast the proposal for demonetization initiated by the central government with that initiated by the central board of the bank. When the bank recommends demonetization, it is, in my view, only for a particular series of banknotes of a particular denomination as specified in the recommendation made under subsection 2 of section 20 of the Act. The word any in subsection 2 cannot be read to mean all. If read as specified or particular as against all, in my view, it would not suffer from arbitrariness or suffer from unguided discretion being given to
The five-judge bench believe that the demonetization process was legal and cannot be struck down by Supreme Court, and the legality of Section 26B of RBI Act 1934, which says that the central bank, in consultation with the central government, can announce to seize the legal tender of any denomination if need be, given there are reasons behind it, while Justice Nagaratha says that she differs from it. So it's a 4:1 judgment that has come in, where the four judges have struck down all the 58 petitions that were filed against demonetization, while Justice Nagaratna say that she differs on all the 6 questions that Justice Gavai judgment talks about, and hence it's a 4:1 judgment. Supreme Court, in the big relief for central government, has upheld demonetization that happened on November 8, 2016. The notification of central government on November 8, 2016 has been upheld by Supreme Court in its 4:1 judgment today.
All right, that was my colleague Rishabh getting us the latest. Just to tell our viewers what has happened so far, on one hand, Justice Gavai has said that it's valid and satisfied, but on the other hand, Justice B.V. Nagaratna has questioned all the 6 points that were raised. In fact, like Rishabh did point out, at the moment it is a 4:1 judgment. Justice Nagaratna has said, as for the section 26(2), the proposal for demonetization to emanate from the central board of the RBI, also gone on to say that her views on each of the questions has differed from Justice Gavai's response to the questions he has framed. Also gone on to point out that when the proposal for demonetization originates from the central government, it is under section 26(2) of the RBI Act. It is to be way of a legalization. If secrecy is needed, then by way of an ordinance. So that is the big development that's coming in. But remember, in the larger scheme of things, the top court has upheld the demonetization decision.
The Parliament, and depending upon the passage of the bill as an act, carry out its proposal of demonetization. Then they are given the reasons for the same. And I've said why it should be through the legislative process. A parliament is often referred to as a nation in miniature. It is the basis for democracy. A parliament provides representation of the people of a country and makes their voices heard. Without a parliament, a democracy cannot thrive. Every democratic country needs a parliament for the smooth conduct of its governance and to give meaning to democracy in the true sense. Parliament, which is the center of our democracy, cannot be left aloof in a matter of such importance. Its views on the subject of demonetization are critical and of utmost importance. nobody states that the impugned Gazette notification dated 8 November 2016 of the central government was published on the initiation of a proposal of demonetization by the Central Board of the Bank. Proposal for demonetization was initiated by the central government by a letter dated 7 November 2016, addressed by the Finance Secretary to the Governor of the Bank. The central government, having obtained the advice of the bank on its proposal, proceeded to issue the Gazette notification on the very next day, dated 8 November 2016. The same was followed by an ordinance, and thereafter an enactment was passed.
All right, so that's the latest that we're getting in terms of the Supreme Court's decision, where the top court has upheld the demonetization decision. But remember, this is a 4-1 judgment that has come. In fact, Justice B.V. Nagaratna has said that she differs from the points that was raised earlier by Justice Gavai, who went on to call the decision valid and satisfied in connection with the demonetization that did come into effect on November 8th, 2016. Just to quickly tell our viewers what Justice B.V. Nagaratna has said. She's gone on to point out that when the proposal for the demonetization originated from the central government, it is not under the Section 26(2) of the RBI Act. It is to be a way of legalization, and if secrecy is needed, then by way of an ordinance. All right, for more on the fact that the top court has upheld this judgment, I have a guest joining me on the broadcast, Dr. Santosh Mehrotra, senior economist, joining us. Mr. Mehrotra, I appreciate you taking the time out and speaking to us on Mirror Now. How do you view this particular judgment that has come in right now? And if you could also help us, understand this judgment and break it down. Because on one hand, it is a 4-1 judgment where Justice B.V. Nagaratna has differed in terms of making her point of view. So your first reaction on that front? All right, we'll try connecting with Dr. Santosh Mehrotra over there, who is a senior economist, to give us his viewpoint about the fact that the top court, of course, has upheld the demonetization decision. Just to talk about the fact that petitioners had challenged this earlier, but the top court now has upheld that decision. Just to give our viewers a sense of what was raised in the counter arguments earlier, Chidambaram had said that the scrapping of the rupees 500 and rupees 1,000 currency notes was deeply flawed. And in fact, talking about the fact that the RBI had earlier admitted in its submissions that there was temporary hardships, and that too those are an integral part of the nation building process, but there was a mechanism by which problems that arose were solved. So talking about this, a 5-judge Constitution bench of Supreme Court just a couple of minutes ago rejected the challenge by the 58 petitioners to the Union government's 2016 decision to demonetize rupees 500 and rupees 1,000 currency notes. Now remember, all of us in the country, of course, did see that coming into effect on November 8, 2016. So now the top court has upheld that particular judgment, saying that the decision has been upheld. In fact, Justice Gavai went on to call that previous decision satisfied and valid. All right, to give us his viewpoint about the judgment that's come in, I have Advocate Chirag Nayak joining us on the broadcast. Advocate Nayak, appreciate you taking the time out and speaking to us on Mirror Now. The fact that this judgment has come in, before we go and break that down for our viewers, your first reaction about the fact that the top court has upheld the judgment.
Hi, good morning. Thank you for having me. I think it was more or less an expected position that, this order, this move, the demonetization will be upheld. And, but the main point is that, this judgment should lay down safeguards for the future, because governments coming in successively should not have a straightaway say in, making major policy decisions on financial economy of the country, because those decisions may be swayed by emotions or other different factors which are not relevant or may not be in consonance with the economic or democratic process. So I think it's a very welcome judgment. I think we need to have a detailed review of the judgment to see what safeguards does the Supreme Court lay down for future generations.
Also, talking about one of the sections that was predominantly spoken about is the RBI sections 26B. If you could just help us, in layman terms, understand what that really meant, and the fact that, of course, the petitioners also had put forth this particular challenge. All right, we'll try connecting with Chirag Nayak, the advocate, to give us, more of his viewpoints about this. But just to quickly break it down for our viewers as to what is really happening at the moment. Remember that the demonetization effect had come into place in 2016 on November 8th, in fact. So that particular decision was being challenged by 58 petitions. But the big breakthrough that's coming in right now is that the Supreme Court has said that it is a valid exercise. Number one, Justice Gavai going on to say it is valid and satisfied. In fact, 58 petitioners had challenged that particular move on several aspects. In fact, in an affidavit, the center told the Supreme Court that the demonetization exercise was a well-considered decision and a part of a larger strategy to combat the menace of fake money, terror financing, black money and tax evasion. These are, of course, the counter-arguments that were made previously. And a five-judge constitution bench presided by Justice S. Abdul Nazir had reserved their verdict after hearing elaborate arguments by the petitioners, the centre and the RBI. So now the big breakthrough that we are getting here, of course, just to quickly tell our viewers as to what Justice Gavai said. He did call the earlier move valid and satisfied. But of course, on the other hand, Justice B.V. Nagaratna raising several points and saying that her views on each of the questions that was put forth by Gavai, to the questions he has framed, her viewpoints differ. In fact, she said that when the proposal for the demonetization originated from the central government, it is not under 26(2) of the RBI Act. And as per the 26(2), the proposal for demonetization to emanate from the central board of the RBI. In fact, she went on to point out that demonetization of all series of notes at the insistence of the central government is a far more serious issue than the demonetization of a particular series by the bank. So she went on to point out that it has to be done through legalization than through executive notification. Now, other pointers that were also made, that Justice B.V. Nagaratna, of course, in her dissent, holds that the demonetization of the whole series of rupees 500 and rupees 1000 currency notes had to be done through a legalization and not through a gazette notification. In fact, she's pointed out that Parliament is a miniature of the country. Parliament, which is the centre of democracy, cannot be left aloof in a matter of such critical importance. Just to tell our viewers, these are all the live reactions that were coming in from the Supreme Court, as and when we're getting you live visuals from the judgment as well. In fact, Justice Nagaratna said, on looking at the record submitted by the RBI, there are words as desired by the central government.
में जो पॉइंट्स हैं वो अब एकेडमिक हो गए हैं, ये कहा भी था, मगर उन्होंने फैसला किया है।
सुप्रीम कोर्ट का फैसला आ चुका है नोटबंदी को लेकर। केंद्र सरकार के इस नीति को
All right, so that are the latest reactions also that we're getting in terms of the fact that the top court has upheld the government's order on demonetization. The demonetization, of course, came into effect in 2016. But quickly to sum it up in terms of what are the reactions that are coming in from the Supreme Court, as we did get those live visuals as well. The fact that Justice Nagaratna has differed from the opinion of Justice Gavai. In fact, some of the key points that she's gone on to note is that on looking at the record submitted by the RBI, there are words as desired by the central government. This demonstrates that there was no independent application by the RBI. The entire exercise was carried out in 24 hours. So the entire context of this is the questions that were raised about was under the section 26B of the RBI. And she's also pointed out that the parliament is a miniature of the country. So she upheld that there was no independent application of mind by the Reserve Bank of India for demonetization. Now, she also said that the proposal originated from the central government and the opinion of the RBI was sought. So such an opinion given by the RBI cannot be construed as a recommendation under Section 26(2) of the RBI Act. But on the other hand, the fact that Justice Gavai has said that the decision will be upheld and it is valid and satisfactory.